Anti-money laundering laws have become the cornerstone of financial regulation for the past 2 decades. We can say that AML laws have become laudable for the prevention of money laundering and counterterrorism. There has been an erosion of presumption of innocence when it comes to AML in transaction monitoring. So what does this mean? It means that people for, withdrawing small amounts of cash can be potentially criminally investigated for using cash which is legal tender. And how have we come to this? This is the question. Now, in one of my previous employments, there was a case of a Ukrainian gentleman who was a farmer. He was living maybe about 10 kilometers away from the Donetsk Oblast because of the recent events going on in Ukraine. The Donetsk Oblast is under sanctions, but he was still living in a non-sanctioned area of Ukraine. Because of a 200 euro transfer to his daughter in Poland, he was criminally investigated for money laundering. And here comes the question, where is the fine line between normal AML investigations and complete surveillance? In the recent years, we've seen, especially in countries like the United Kingdom, that people who have withdrawn, let's say, 1,000 euros or 1,000 pounds in cash have been investigated for potential money laundering. And the erosion of presumption of innocence is a complete violation of constitutional standards and the European Convention of Human Rights. You see, the European Convention of Human Rights in Article 6 enshrines the fundamental presumption of innocence. So any person accused of a crime is innocent until proven guilty by a court of law. So modern AML regulations don't take into consideration normal financial activities of everyday people. We've come to the point where a simple cash withdrawal becomes a risk incident. We've come to a point where payment in cash can constitute a criminal offense. Now, as a legal professional who strongly believes in the Constitution, that is a big problem. Imagine you are married to somebody who is not from your country, and you are, because of different regulations, you have to send money via bank transfer or via crypto in some cases. Just engaging in a simple transaction, let's say to a country that has certain sanctions. Imagine there is a life and death situation. Imagine, for example, you have a mother who's living, let's say, in Syria or Iran, who requires urgent medical treatment. And because you are a good child, you send maybe $100, $200 to them. That can not only get you criminally prosecuted in your country, in the European Union, it can actually get you an Interpol red notice issued by the United States. Now, you might think this is, some kind of conspiracy theory or exaggeration, but these things have actually happened. So there was this case that I'm aware of I believe he was a British citizen. He was a sort of YouTuber, and he attended, just as a complete meme, he attended the Pyongyang Crypto Summit. Just for a meme, like, a lot of these travel YouTubers do, because, it creates content and it's, just interesting for people to watch. So just because of his participation in that event, when he was in a layover in Saudi Arabia, he got arrested because the United States issued an Interpol red notice for his arrest. So what we are also seeing is the principle of extraterritorial sanctions being in place in the modern financial ecosystems. Extraterritorial sanctions are sanctions that are usually initiated by major geopolitical players, such as, let's say, the United States in particular. The European Union in 2016 signed the Joint Cooperation Plan of Action between the EU and Iran to eliminate sanctions against Iran for their nuclear proliferation. However, after the United States withdrew from the JCPOA agreement, at the time, the Trump administration, they not recreated. The Trump administration again launched sanctions against Iran. Because of US extraterritorial sanctions and because of the US monopoly over the global financial system, the United States can theoretically impose its own sanctions against European countries, against allies, for conducting normal business relations with countries that they deem a geopolitical threat. Now, when I went to law school, when I joined law school, I was a huge believer in international law. I was a huge believer in this kind of holier than thou diplomacy of international law, only to realize international law has become a crock of shit. And it's become precisely a crock of shit because it's based exclusively on political polarization between the so-called good guys and the so-called bad guys.